Now let's discuss certain specific issues in exhaustion relating to self-replicating technologies. Now self-replicating technologies are those technologies wherein by virtue of the nature of technology itself it makes copies. So if I were to buy a self-replicating technology and without my active involvement, if there is any kind of replication, would I be entitled to those copies that arrive out of such self-replicating technology is an important question. In Baumann versus Monsanto, a decision of the Supreme Court of United States, the US Supreme Court came to a conclusion that in relation to self-replicating technologies, the regime of exhaustion that is followed would be the first sale doctrine. However, it applies only to the exact copy that was purchased from the buyer. Now, Baumann's argument was that since the technology is self-replicating, he should be allowed to save and resow the seeds and resell them by virtue of the first sale that occurred in relation to the original product that was purchased from Monsanto. So by virtue of this decision, the US Supreme Court came to a conclusion that if Baumann's argument in relation to first sale doctrine was adopted, then in self-replicating technologies, the IP owner, the patent owner, could never exercise effective control on further sales in relation to self-replicating technology, and it would directly compete with his market and monopoly. So the Supreme Court of the United States clearly said that although first sale doctrine applies in relation to patents, it is limited to the exact first copy that was sold to Baumann and not to outcomes and produces in relation to self-replicating technologies. In this case, Baumann was replanting Monsanto's genetically modified plant varieties, and by virtue of these plants being self-replicating, he was using those seeds to resow them every year and was making profits out of it, and the Supreme Court struck down Baumann's claims in relation to first sale doctrine by limiting the scope of first sale as being applied to only that particular product which was sold to him and not further copies of the product. Second is the issue of exhaustion of copyright in relation to products that are ancillary but do not directly infringe copyright. Now in situations where suppose if the patent law allows international exhaustion, the trademark law allows international exhaustion, it is important because in India, since by virtue of court decisions national exhaustion is largely followed by most courts, it would be important to consider whether importation of products and ancillary infringement of copyright would be exempted. Now in a situation where if you import a patented product or a trademark product, and if international exhaustion doctrine is applied, it will still be an infringement of copyright if there is valid copyright in labels and valid copyright involving artistic works. Now to avoid this situation, in 2012 when the law was amended, the legislature clearly included a provision called 51ZC which mentions that the importation of copies of any literary or artistic work such as labels, company logos or promotional or explanatory material that is purely incidental to other goods or products being imported lawfully, this shall not amount to an infringement. Now by virtue of this provision, if anybody were to import a kind of material that would in ancillary involve violation of copyright, it would not amount to copyright if it is otherwise valid under law to be imported. Now this section is very unique, that because although national exhaustion regime does not apply in relation to copyright law, we have tried to create a minimum kind of small limitation in relation to a purely incidental infringement involving copyright. In summary, we may conclude that the property law principles do not allow to impose an absolute condition on sale which defeats the purpose of deriving value from the property, and hence any vendor cannot impose a condition which states that the buyer of the property cannot further sell it. This condition has been extended to intellectual property by way of the first sale doctrine, which means that a buyer of an IP protected product can further sell the same physical copy of the product and not make multiple copies. However, the first sale doctrine is going to help only with reference to the exact product and not the technologies that are reproduced. Furthermore, there are certain exceptions in relation to both cinematographic films and sound recordings, and also computer programs that are envisaged both in the TRIPS agreement and also in the domestic laws, where the basic idea is that in relation to these works there is no exhaustion or first sale in itself. We also discussed the principles involving national exhaustion and international exhaustion, wherein we have discuss the nuances of what it means to have national exhaustion where parallel imports are not allowed, and what it means to have international exhaustion where parallel imports are allowed in various kinds of intellectual property protected works. However, regional exhaustion is an extension to national exhaustion. We also discussed the arguments for and against international exhaustion. Primarily, the arguments have been relating to the fact that international exhaustion may discourage IP owners from price discrimination, and it is also important to understand that price discrimination, if not followed, would lead to consequences on consumers. So that has been the argument that IP owners have upheld. But we have seen that in relation to a large majority of IP protected products, in certain cases price discrimination may not be followed, and that's where international exhaustion can be quite useful. In relation to TRIPS, we noticed that Article 6 of the TRIPS agreement does not lay down any kind of principle or definition of exhaustion. Hence, member countries are free to determine any regime of exhaustion, provided it is consistent with other provisions of the TRIPS agreement, and provided you comply with section Article 3, that is national treatment, and Article 4, that is MFN, most favored nation treatment, in relation to the TRIPS agreement. In relation to exhaustion of patent rights in India, we notice that section 107 clause AB precisely does not clearly lay down any particular regime of exhaustion, but if you look into the statement of objectives and reasons and the amendments that were done in relation to clarifying the meaning of exhaustion, it leads to a kind of conclusion that the exhaustion regime that is adopted in relation to patent law is international exhaustion. However, there is a lot to be expected from the type of clarity that is needed in relation to this particular phrase, imported from duly authorized by law from some other country, that needs to be clarified. In relation to copyrights in India, it's very clear from the court decisions that court decisions mostly have favored national exhaustion. We also discussed some off-bit decisions where parallel exportation has also been prohibited under Indian law, which is kind of per incurium. In relation to trademark law, we looked into the division bench decision in Samsung, and we have come to a conclusion that the principles of international exhaustion are clearly laid down in trademark law. However, this decision has been challenged in the Supreme Court. In specific issues relating to exhaustion, we discussed the Baumann versus Monsanto decision, wherein the Supreme Court of the United States has come to a conclusion that in relation to self-replicating technologies, the self-replicating technologies have an inherent ability to replicate, and in such situation there is in relation to such additional copies or the self-replicated ones, there is no exhaustion as such. So the exhaustion applies essentially to the first copy and not to further replicated copies. In relation to copyright copyright infringement of products that are imported and ancillary infringement, we know that the recent 2012 amendment has included a provision in relation to fair dealing under section 52, which allows that any kind of infringement as an ancillary to a product being imported, a copyright infringement in relation to a product being imported is not considered as infringement within the copyright law. So in summary, we can come to a conclusion that although there has been an attempt by intellectual property owners to kind of argue and articulate a premise for international exhaustion, countries all around the world are moving towards in summary, we can conclude that although IP owners have been demanding national exhaustion, largely courts have all across the world have denied and have sought to interpret international exhaustion as the underlying principle, more in line with the objectives of free trade and in the welfare of consumers. Thank you one and all.